Good afternoon, Your Honor. This court is aware I do represent the petition this matter, Nate and Christine West. We're here on my client's motion for temporary orders as it pertains to largely financial circumstances of the parties and my client's much needed relief therefrom. Start by noting that these parties were married back on December 15th of 1995, recently separated in September of 2023, making this, by my math, about a 28-year marriage. One remaining child both parties are legally responsible for. That is 18-year-old Mihaela, as the parties stipulate and agree to two grown and adult children. That's Aaron and Nicholas. Again, here primarily on the financial issues. My client details for you in her pleadings, specifically the declaration of the financial budget and attachments, her need for some support. This is a case in which, to his credit, Mr. West was largely the breadwinner of the family throughout this long-term relationship. He works for the union as a pipe fitter and has done very well for himself over the course of this party's relationship. In our estimation, that shows no signs of changing anytime soon, despite his comments to the contrary. Currently, as it pertains to Mihaela, she is recently turned 18 in January, but is still a senior in high school, is doing very well. She'll be graduating. She'll be moving on to college in Minnesota. We anticipate here at the end of the summer or early in the fall. And you'll see in our pleadings that we have requested to reserve on the post-secondary language, but enter a child support order pursuant with the child living exclusively with my client, 100% of the time. There has been some issues. I'm not going to discuss those at this point because I don't think they're necessarily germane to today. I would like to keep the privacy for the parties before you as well as that of the child. There is an ongoing investigation. Don't think it impacts anything for today, but nonetheless, just want the court to be aware of that. So I'll rest on my client's comments in her reply declaration, but that's kind of where we're situated. As it sits today, and again, I don't think there's a large dispute. My client was largely throughout the relationship a stay-at-home mother and wife. She did good on that. She homeschooled Aaron. Aaron is now doing relatively well. She managed the home. Mr. West traditionally not only worked, but worked long hours. Worked extensive overtime, and again, largely to his credit, withheld certain taxes so that he could get the bigger return again at tax season. That's been traditional. That's largely happened. I'll get down to a fine-tuned analysis here in a minute of that. Nonetheless, if you look at the information before you today, and there is certainly, when we look at RCW 26090, one party's need versus the other's ability to pay. Mr. West definitely has an ability to pay. My client certainly has a need. We are asking the court to combine the child support with the spousal support as requested. Family maintenance, I know that that's probably comes under the guise of that. I think on a temporary basis until Mihaela graduates high school in the middle of June this year, that's probably appropriate to do, to put both of these people in some kind of financial parity, because right now there's not. If you also look at this, this has the added twist to this, which again is beneficial to the parties and the financial circumstances of both. There is a rental property on the home site. This is about a 5.5 to 6 acre parcel of land in Cathlamet, in which there's the family home. There's also this rental. It's been rented by the information provided by Mr. West at least since June of 2022. It's been the same renter that's being rented for $1,400 per month. If you look at the financial aspect of this real property, it's interesting. This again is on the 5.5 acres. This has a nice sizable home. I believe it has a shop on the property. It has the rental parcel on the property. Mr. is living in the primary home. It's rented out, and he's doing that for a remaining mortgage of only about $1,100 per month, $1,170 to be specific. My client recently, when she moved from the home after the holidays, moved to basically a basement apartment in Longview and she paid $1,200. So she's paying more for that basement apartment that she's renting than Mr. is to live again on 5.5 acres in his own big residence in a parcel in Wahkiakum County. So again, if we're looking at that, we're going apples to apples. He is in a far better financial circumstance and living circumstance than my client is, who has two mouths to feed. Not only is there her, but there's also the 18-year-old daughter who doesn't graduate for several more months. That needs to be accounted for. Looking specifically at the incomes, and again, this is where we get a little bit back and forth and a disagreement on where each party stands. My client details for you when she was able to finally go back to work. She's a nurse, that she did that on a part-time basis. And those part-time efforts were further complicated when she was injured at work. Now she gives you the specifics. I'm going to have to read it because again, it's like a foreign language, the medical stuff. She suffered a significant back injury, a herniated disc in the L5, and damage to the sciatic nerve. She details for you in depth the process and the treatment options and everything that she has done since being diagnosed with that back in 2018 to try to get herself in a position to work more hours. She hasn't. Parties recognize this. And again, this is 6 years ago. So she's been battling this for a period of time. Mr. West agreed to purchase and accommodate these issues, agreed to the fact, and again, I think is all you got to look at is the date of the injury, 2018, what they've been doing since. Agreed to get her the special chair. They agreed to purchase her a vehicle with a seat that would accommodate the back issues. They agreed for her to work for 12 hours, just basically to supplement the income. And that's what she's largely done. I think it's completely disingenuous for him to come at this point on the eve of a hearing and a divorce and say, well, she could work more if she wanted to. She's turned down work. When again, the history of this, and I'm not talking just the last 6 years, I'm talking about the last 28 years, has been where my client has only really worked part-time for the majority of that. This was set in motion by agreement of the parties and has been what has traditionally occurred. We provided you recent wage information showing what my client earns. Excuse me. She's taking home a net pay. And again, this was based on pay stub information at the end of the year of $20,615 or about $1,718 net per month. The fact that she's now treating, and this is that she details for you, she has an attorney helping her with the L&I portion. L&I turned her down initially because they said this was a pre-existing condition, not something that happened at work. Regardless, it puts you in the same spot. Whether this is an L&I claim or a workers' comp claim or a Social Security disability claim, the fact remains she can't work a full 36 hours that most nurses do, being on your feet for 12-hour shifts in what it can only be considered a rather physically demanding capacity. So we are asking you whether you impute her at full-time minimum wage, as Mr. West suggests, or take what her actual wages are of the $1,700 per month. Still puts her in a significant need for support. We provided you with her monthly budget, again, between the expenses for Mahela, the rent, the other expenses, again, depending on what you do with credit cards and such. And we are asking for a form of alimony or support in the amount that we specified in our motion. If you look at Mr. Again, a union plumber pipe fitter, currently for charter mechanical, he's making significantly more money than she is. My client gave you 2022 year-end tax information, which shows his income was approaching $150,000. Again, more specifically, $147,671. If you just take that, and that's not including everything else he does. If you're just taking that set amount, that's $12,306 per month in gross income. That does not include what he's taking out, receiving for the rent proceeds. It doesn't account for all the overtime opportunities. And as we state for you, he's traditionally worked a lot of overtime. That's just the bare bones amount that he has. He's also got the union pension, the 401k as mentioned, and the medical insurance. He is in a far better position than my client. And his only real debts is the mortgage, which is covered by the renter if we want to take that approach. A couple of credit cards, which again are nominal, and the 2 car loans. There's my client's car, and there's his pickup truck, which account for the 2 auto loans. He's pocketing significant money. If you look at what was provided in the responsive declarations, you'll see that his contributions to his 401k alone far exceed the statutory limit. If you look at what he's done year to date, he shows voluntary retirement deductions of $17,559, which again, by my math, equates to about $1,463 per month he's plugging away his retirement. He also details for my client and tells her not once or twice, but several times since they started contemplating divorce, I'm going to cut back on the overtime because the court can include that as part of my income analysis. So again, looking at those things and the contributions of that, the fact that he is plugging money away, the fact that he has traditionally worked those types of overtimes, and you compare that to his budget, which is reasonably based, but it doesn't show that he has anything but an ability to pay support as requested. If anything, I think our request for support is extremely conservative when it comes to the actual incomes of these 2 parties. We are asking that he make the auto payments. That's $319 for the BMW. That's $550 for the pickup truck that he drives. We have the credit cards. Again, depending on how you go with that is obviously going to impact the support amount. Child support alone, based on our calculations from the 2022 income analysis, would be about $1,272 per month owed by Mr. West. Also asking for the spousal support in the amount of $2,550 per month, or as I've said earlier, family support of $3,772. That doesn't equalize the incomes. you put my client's amount that she's earning through her wages at the hospital in that puts her a little bit over 5,000. He's still above that. And again, you're pretty much equalizing the debts and the monthly obligations through bills. Also, and this is what we need to contemplate as well. When you look at the rental income of $1,400 per month, I've suggested, and the council and I have spoken a couple times or several times on this case, but not specifically about this. I don't know what her position is, but we're asking that the rent of $1,400 per month just be split between the parties. We don't need to call that support. We can just call that, some kind of a transfer payment through a joint community asset on the real property, and that they both have access to those extra funds, since my client is certainly going to need that to sustain her household. And again, 2 mouths to feed versus 1. He's coming out on the high end of that based on his income, also based on the fact that he can, despite what he says, work overtime whenever he wants to. Finally, we are asking for a contribution in attorney's fees and costs. My motion specifies $3,500 in my preparations for this hearing yesterday. I see that was inadvertently in my declaration, reduced to $1,500. That's my error. We are asking for the $3,500 in attorney's fees and costs. My client did scrape funds together to make my retainer. My retainer was in excess of the $3,500, but nonetheless, we do believe that that's reasonable. Again, given the income situation, the long-term status of this marriage being 28 years, plus the other factors contemplated in the statute. Any award of fees and costs we ask to be paid within 90 days of entry of the temporary order, and that gives Mr. time to collect that and pay my office as such.
Just one clarification, and maybe I missed this on I'm looking at the financial declaration. I didn't see a 401k deduction coming out of there.
My clients?
Off of Mr. West.
I was actually going to explain that to you, Your Honor. So he contributes toward a vacation pay. That's the voluntary retirement that they're talking about. They have to purchase their vacation time. Isn't that correct?
Not really. That comes out of my pay. I'm not paying into a 401k, and I haven't been since November.
That's why you didn't see it.
Okay. All right, go ahead.
Okay, thank you, Your Honor. I'm Lisa Martin. I represent Derek West in this matter. I agree with counsel on some of the basic facts. I think he covered that very well, and I won't bore the court by going over that again, length of marriage and all of that. I think where the heart of the matter lies is the incomes of the parties. And one thing I want to draw your attention to is, while wife did explain her back injury in her declaration, please notice that she offered no medical records of any kind to substantiate what she's saying. She told my client during the course of the marriage that she was literally declining employment because she could and she wanted to. Now she is seeking a divorce and things have changed and she needs to come to the table and start earning some income. But I really think it's important to understand that there is no evidence whatsoever of the allegations that she's making, period, none. As far as his income is concerned, we provided 3 income analysis. I don't know if you had an opportunity to look at those.
I looked at everything that was in the file, so.
Okay. So we talk about his 2023 net income, which we calculated at $6,822. Then we calculated prior to his demotion, which was as a result of this criminal investigation, which we won't go into detail about today. Prior to that demotion, he was earning $6,857. Now he's a journeyman, not a foreman, and he's earning a net income of $6,106. The income numbers that wife provided to you are old. She provided a 2022 W-2. She provided an old wage stub that is not up to speed with what he's currently earning, in part as a result of this criminal investigation. There was some commentary in her declaration, her reply specifically, I noticed, that they believed, or she believed, that there was more lucrative income available because there's intel jobs opening up. And what I want to point out to the court is that these type of jobs require security clearance. They have to go through extensive background checks in order to work at a place like that. Depending on what happens with this investigation, I mean, he's innocent until he's proven guilty. He may never be able to get that kind of clearance. He's not going to earn the money that he used to earn. So that's why we would ask the court to accept our income number of $6,106. The attorney's fees issue is need versus ability to pay. And again, I would point out to the court that there was no evidence of any medical issues. She can work more than she is. She has 4 credit cards that she can utilize. My client's in the same boat, Your Honor. He was able to pay my retainer, but just barely. And this is going to be what I perceive to be a contentious battle until it's over. They both have no money. There's not enough money to go around at this point. So we would suggest that they each pay their own legal fees. As far as the rental income goes, splitting it, that's probably okay. They were depositing it into a joint account and then withdrawing it as they needed. She actually got the benefit of one of those withdrawals for her attorney. My client did as well. We're not trying to hide that. I guess the other issue too is that we need to have a start date, and our position is that this should not start, the support obligation should not start prior to March 1st.
Okay. Can question, and maybe you already answered, there's a vacation dues thing, and I don't know what is that?
Go ahead. Can I let my client explain?
I don't know what it is, so.
It's an account set up that when the contractor pays us, it's paid into the union, $2.65 per hour. It just goes, it's in essence, still part of my income. It is part of my net income. I can withdraw that out of an account at any point.
So is that a mandatory deduction?
It is. But to be honest, I can still pull it out every month right after it's put in there. So
Okay.
I'm not trying to hide nothing.
Okay. All right, Mr. Zandy?
Yeah, and thank you, Your Honor. Again, this is a case where my client's been out of the primary home since the first of the year, and my client's gotten nothing on behalf of child support loan, just something for Mihaela. We don't have anything for that. So if we're setting this, I would ask that be set back to January 1st. As far as and again, the statements that there's not enough money to go around. There's certainly enough money to go around. And I think it's interesting, if you look at the information provided directly from Mr. West's employer, it states, quote, "We are fortunate over the past decade to see record work in our area." Sure, nothing's promised. Nothing's promised in any industry. But nonetheless, if you look at the track record, and we have the benefit of looking past the last 20 years as to what he's made, and there's more than enough with that. He's pushing $200,000 in most years. It's interesting, in 2023, all of a sudden now he claims, well, I'm not making as much as I was through using old information. If we looked past that and we looked at the past 5 years only, we'd see that his income is surpassing $150,000 easily every single year. This comment and this argument that my client is voluntarily underemployed, again, that doesn't fit with the narrative of the past 28 years of marriage in which she's homeschooling the children. She goes back to work and tries to get there to 36 hours full time and injures her back in 2018. There's no dispute that she's hurt. It's just, well, we don't see enough medical information. And again, this is the initial basis of a divorce. These parties have been going through criminal investigations. My client's been trying to get the child enrolled in counseling and the like. Counsel and I, although we work very well together, have not had the opportunity to exchange formal discovery. This will all be forthcoming. This is temporary. This is just to set and make these parties in equal position moving forward so that they both have enough to sustain their household. I would argue there's plenty of money, there's plenty of resources to do that. And as far as the money for the vacation fund or the voluntary 401 contribution or whatever it is we want to call it, that's another pool of money that he can draw from. And you just heard him explain that to you. To be honest, I can pull that out when I need to. That's his comment. That's not in his declaration, but I again, appreciate the fact that we have that now. The position of this is my client certainly has the need. He has the ability to pay. This is a long-term marriage. This is a case in which you, again, go apples to apples. This is a case where he does have more than enough, more than sufficient funds to provide and meet his budget. My client needs to be put in the ability and the position to do the same for her and this 18-year-old child who is still a dependent of these parties and should be treated as such.
Your Honor, may I add something that came to our attention that I forgot to mention? Is that right?
That's fine. I have a question myself, but
So just prior to filing, or maybe shortly after filing our declaration, my client learned that mother has applied for the adoption fee in California. It was, I think, terminated for a period of time, and she's reapplied for it. I don't know the status of that, but we did notate that in the financial declaration. I believe it's $1,275. Right. So that's other income going into her pocket until the child goes to college. So I think we have to consider that. And she doesn't really mention it in her declaration.
And she did, she did apply for that. There's been no fine, there's been no determination. Once the child turned 18 in January, that ceased. At my instruction, I said, try to get that money back. We don't have any.
so that's not currently happening.
Correct.
Okay, that was my question. So it was.
And I do want to put on the record too, with the permission, that we did agree to file a joint and married 2023 tax return. We will put whatever refund we collect as anticipated in the trust account of McKean Smith, and we're agreed on that.
Yes.
Okay. All right. So when I looked at, and again, I'm looking at the most recent, it looks like his income, when I calculated, it's closer to 9,900 as a gross. So I think when I'm looking at this worksheet that I believe Mr. Zandy filed on the child support worksheet, I guess what I'd want to do is change the gross to 9,900 and then that 416 is, it's not a 401k, but it sounds like it's money that really is not, it comes out, but it's available. So that should probably be pulled out of the deduction. But there should be, I assume there are some union dues that need to be added into that calculation, which are not in Mr. Zandy's worksheet.
Correct.
So if we can rerun those numbers, that'll give me a better feel for that. That's going to probably drop that about.
So take out the 416.70 that we gave him credit for, add back in his union dues.
His union dues, but decrease the gross to 9,900. That's what the 2023 documentation shows, based on what I calculated. And I assume that's going to make a fairly significant difference in that amount. She's currently showing a need of around 3,000, and you're asking how much?
30, good question. It was a weird number. 3772 plus the 700 for the offset in the rental income. I give you that number exactly. 3772 is what we're asking in family support.
Okay. So I think what I'm going to do at this point, and this again is temporary. This may change as we get more information through discovery, and I certainly can come back and readdress this if it looks like there's some significant changes. I'm going to order on a temporary basis. This be family support. So whatever, the child support is going to change, but I'm just going to include that in here. I'm going to order $3,200 family support plus the 1/2 of the rental. And I believe that's 1,400 if I remember, based on the documents I saw. So it'd be 700 a piece that comes through the rental. And again, this is temporary. If there's some real differences in the numbers we're looking at, I do want to know if that adoption support comes through, because I understand it's not income, but it is income in the family, in the home for expenses. So, okay. I'll order that he do pay the 2 vehicle payments, and I think you had, just a second here. He'd pay the things related to the current house. She'd pay her own bills. I guess the question I had on the debts, you got him paying all but the medical bills.
Yeah, my client's paying about $500 a month for her medical bills. It's my position she continue to pay those, and I think that's reflected on her budget. That just leaves the issue of the credit cards, which is about 700 or so per month. I don't know if I don't believe that's the minimum payments, but I think it's around that.
That's for all of those?
500 for minimum.
Right, and
Yeah.
those cards were used during the previous separation, and my client didn't find out about it until much later. So we would ask that she be awarded all of those cards that we identified in his declaration. I think there were 4 of them.
And we dispute that, and that's kind of why we need to get the discovery going.
I don't know how much the payment on each card is, because I don't have that here. Or balances, or
Maybe we could save that issue. Let's get a presentation date 3 weeks out. We can save that issue. I'll talk to Ms. Mark and see if we can't just come to some kind of a
makes sense.
resolution on that
Right.
outside of further hearing.
At this juncture, I didn't see anybody saying there's a big wad of money sitting someplace that's liquid. They're each going to get 700 a month coming in on that rental. So I'm going to, at this point, leave attorney's fees each pay their own. That may change as we move forward.
You want me just to reserve on that?
Yeah, you can reserve on that.
And presentation in 3 weeks, which would put us at the 29th.
Unless you want to do it on this docket. I'm fine doing it on this docket as well. That work. So that put us on the 2nd. I could do either one, but
I could do April 2nd.
April 2nd at 1:30 or 1 o'clock, excuse me.
Okay, and I'll get that turned around as quick as I can. Thank you.
Thank you.
If you do have an agreed order, just submit it ex parte and we can start the hearing.
Effective start date, I'm sorry, you made it
That would be February 1.
February 1.
And based on filing that was late in January. Matter. You have anybody else on that case here?
Yeah, I'm here.
Good afternoon. So this is a request for genetic testing. I didn't see did I see an objection to that?
No.
She filed a responsive declaration, but I would agree I didn't see any objection from her for the testing. So I think at this time, if we enter the order that I've prepared on my motion for genetic testing, and then once we get the results back, then we can address any parenting plan and visitation issues.
Okay, I don't know. I do have an order. So any objection to that, ma'am? That's simply saying you're both going to participate in the genetic testing, and then we'll determine anything else after that's done.
No, no objection.
Okay. So I will enter this order.
And then if you'll just acknowledge on that first page that the respondent did appear, I left that blank.
Will do so. Indicate approve via Zoom and sign that order. All right, I've signed that order.
Very good. Thank you, Judge.
Afternoon.
So we were reviewing discovery status. I saw a declaration that said nothing had been received.
So here's where we are. For the record, I'm Chelsea Baldwin. I represent the respondent in this matter. The original motion that we filed was essentially regarding CR26I as well as CR41B. And that's because we have a long history, essentially a year to date, of really non-participation by the petitioner. And so we have, he files this case. We have a mandatory settlement conference. He doesn't appear. I try to get CR26I with him. It takes a motion to make that happen. We do this, finally get the CR26I. He then doesn't provide materials timely. I will tell the court that he did provide me some materials, but not on the date that we discussed, and certainly not all of them. Kind of I'll provide what I want to, how I want to, is my impression of what I was very recently provided just a few days ago. And so where we are now is really at the place where I'm addressing the CR41 issue with the court. So we have CR41. CR41 is very clear. The case has been pending at this point for over a year. And this isn't a case where there's been active litigation. We have someone who has a history of non-participation in his own case that he filed. This is not a case of a marriage. This is a case where somebody's making a claim of a committed intimate relationship where my client denies that being the case at all and says essentially this is a case of harassment from somebody that was amounted to a relationship, but certainly not a committed intimate relationship, and that this is sort of a land grab after the fact. So at this point, my client is asking the court to follow CR41. Case has not been noted for trial. He's not attempted to note it for trial. We've set it out. He did not use any of that time. It's been set out quite a bit from the original filing of the motion. I think we filed the original motion was back in January. So it's been pending for quite some time. So at this point, it's been months, still hasn't had it noted before the court, and we're asking the court for dismissal.
Mr. Roberts,
Yes, Your Honor.
any response to that?
Yes, I have answered her questions of discovery. You know, I have turned them into and filled them the best I can because all my paper documents and stuff that she was asking for were with our home that I couldn't get to. I was there in court the day that she said I didn't show up. I was at the courthouse. And I was sitting in courtroom 3 and I realized it was supposed to be on Zoom. And by the time the court clerk office got me into the booth, it was too late. I've been trying my best. I'm doing this on my own. I answered the questions she asked the best I could. I gave questions to her. I have not received any answers back to. Just wish to continue this. I want to reschedule a settlement conference. I've done everything I've been told to do from the courts on this matter to fill out. I'm doing the best I can and I'm doing as fast as I can.
So I guess I'm a little confused. You're talking about the settlement conference that was?
Yes.
Zoom?
I was at the courthouse, but I never got a chance to get in to talk to her. They said it was too late. So I would like to reschedule a settlement conference if I could. It really wasn't my fault why I wasn't in there. It didn't say I was on Zoom, and when I tried to get on Zoom, it wouldn't let me in. And the reason that a lot of the problem of this is I moved from my previous address to the new one, and it took 13 times we've done where you redo your mailing, change address. 13 times it took before we start getting our mail, and we're still not getting it all. So I don't know what I can do. I ran out of money for attorneys because of previous things regarding me and her. I've already spent $40,000 on attorney's fees this year.
Oh.
I've already, I took out all my 401k. I've done, and I'm just trying to do this on my own.
When you're ready, Your Honor.
And I have given you all the information you asked for that you had. So I don't know what questions you say that I didn't give you. You gave me like 45 questions. I answered them all the best I could. But now I have put in for questions for Ms. Roush and you, and I have not received anything back on this discovery questions.
Give me just a second here.
What I've gotten from Ms. Roush is their financials and stuff are nothing. There's absolutely nothing there.
I'm just looking at the record in the case here. So you filed your motion on the
January 19th, this motion,
January 9th?
19th.
19th, okay, that's nice, okay.
And I'm more than willing to move forward on this case. I'm just trying my best, Your Honor. I'm just.
So it looks like, I'm not sure that this under 41A, I mean, there was definitely a motion hearing in June of 2023.
I'm at 41B.
I'm sorry?
41B, it would be involuntary dismissal.
So I'm looking,
So 41B1,
41D1?
no, B is in boy. So involuntary dismissal. So any civil action shall be dismissed for want of prosecution whenever the plaintiff, counterclaim, cross-claim, third-party defendant neglects to note the action for trial or hearing within 1 year after any issue, essentially once the case is complete, unless the failure is the result of my client, which is not the case here. I have to give at least 10 days notice to him. Notice has certainly been provided at least within 10 days. And then if he had noted it up for trial in any point between January and now, then that would have invalidated the motion, but it did not.
Check something here. So with respect to that specific claim, sir, did you have any response you wanted to make?
Yes, because the mail is not my fault. I mean, I can't remember if I turned in a statement from the mail people stating that I've had problems with my mail, serious problems. I did not get any of her paperwork until like 3 weeks ago, 4 weeks ago, something like that. So I just want to move forward on this. I'm doing everything I'm supposed to be doing now. I was at the courtroom. I did not, I wasn't there. I tried to be there.
That's a different issue, sir. This is an issue
Okay.
of failure to set it for trial within the time.
A year?
Mm-hmm.
I didn't know about that, Your Honor.
And you said you received this motion 3 weeks ago, is that right?
I guess my wife will. Yeah, approximately 3 weeks ago.
Okay.
When she sent our discovery, Ms. Rouse yeah, and she told me I have 2 weeks. She gave me 2 weeks to turn in the discovery, and I turned in as fast as I could. I wasn't.
All right, I understand. That's a separate issue from what we're looking at today. Okay, so looking at your motion from January, this is the one I'm talking to Ms. Baldwin for a second here, sir.
Oh.
This talks about CR 41 for failure to comply with discovery in court orders, but that's not
Right, so then
B1.
further down, appear or otherwise respond to this motion, relief pursuant to CR 41 and CR 26 for noncompliance and failure to prosecute his claim. I did do that.
I'm just looking at 41B1 though. That's a trial setting issue, which is not what the request is under. So we go back to 26.
Right, but the 41 is failure to prosecute a claim, and that is what 41B1 is. So it's failure to set for trial, but it's for want of prosecution. I mean, the beginning of 41B1 says for want of prosecution.
But that's not the basis of your motion, is what I'm saying.
I guess I see failure to set for trial as want of prosecution. I mean, failure to move your case forward to trial. I
Oh,
pulled
I
the
see.
language.
I was reading the wrong spot of the motion. My mistake. I was reading that part. All right. I think based on that, reading of the rule, this case has been pending for, well, since
March 7th.
March 7th of 23. And there really has not been a lot. And there was, I think given those circumstances, notice this motion was, sounds like it was received at least 3 weeks ago. And there's been a number of things filed, none of which are trial notices, but there are other kinds of hearings which don't appear to be.
I did have the conference with her though last time. On the phone with
I understand that, sir, and that's not the basis of anything I'm looking at here today.
Okay, I'm sorry,
Okay.
Your Honor.
No, you're fine. I'm just looking at the motions that were filed. There's an order to show cause for a vacate of a judgment. There are a couple of other motions. I see, but I don't have a trial setting. So I'll grant your motion under 41.
It has to be set over 2 weeks for a presentation. Well, let's make it 3. I want to make sure it gets to him.
Over to the second.
Yes. Let's make it 4 weeks then. I think I'm not here on the 2nd.
Over to the 9th of April. So basically, sir, what that means is she's going to prepare an order, send a copy to you.
Okay.
Essentially, the case is going to be dismissed for failure to prosecute the case within the timelines.
How, Your Honor, can I ask you a question? I can't answer I answered it in the best time I had when I
This
first got.
has to do with not setting the trial for a year after setting.
I didn't know when to set a trial, Your Honor.
All right.
I didn't know.
All right. You certainly can get some legal advice as to what your next options are, but as of right now, I'll come back for an order, and that would be on the 9th, looks like.
Yes.
9th of April. And I suggest you get some legal advice, sir.
And I'll send that order to you, the proposed order to you, sir.
All right, thank you.
I always see everybody on my screen, so I just was checking to make sure you're here. All right.
Perfect. And if I could, Your Honor, I just wanted to give the court a brief update without teetering too far into ER 408 territory. We are seeking mediation through Community Mediation Center. Mr. Zanti and I have been in touch about that a number of times. What my understanding is that my client has paid for her portion of mediation. Mr. Zanti indicated to me that his client paid his fee yesterday. However, we received an email at 9:02 this morning from the Community Mediation Center indicating he had not paid. In that same email, they indicated there's availability for April 19th for mediation. In my discussions with Mr. Zanti, we'd love to get something sooner, and hopefully we're able to do that. But at the very least, we're looking for an April 19th mediation. We are kind of in an interesting situation in the sense that one of the main issues that is present for today's hearing is a little bit time sensitive. There is a trip to the Bahamas that all 3 individuals in this case, plaintiff, respondent, as well as the child involved, have tickets for, and we did want to get some clarification on that as soon as possible, probably even sooner than that April 19th date. And of course, Mr. Zanti, feel free to jump in at any point in time, but if Your Honor does wish to go in and make some additional rulings regarding parenting plan provisions, we are more than willing to do that today. It is something that these 2 are good parents, but there just needs to be some provisions put in writing, put in place, so there's no confusion, no issues moving forward. I think our pleadings lay out that there's been some communication issues that have made co-parenting extremely difficult, and we can go into all of that, but right now the gist of the matter is we're on the precipice for mediation. Hopefully we can get this case resolved at mediation, but we do need a quick answer on the Bahamas trip, and if need be, even more guidance, even more written rules, just to make sure there's no issues moving forward.
Okay.
Do I have that correct, Mr. Zanti? Sorry.
Yes, I think you're pretty close, counsel. I can say this, though. I was incorrect this morning on the phone. My client has the money. He's gonna head over there and pay as soon as we're done here today. So I don't know about the 19th. If that's an available date, I'd have to confirm with my schedule. I think counsel and I both agree that parties do want to participate in mediation. I think that's pursuant to the local rule. I'm fine with the middle of April, schedule permitting. We need to bridge the gap between now and then with visitation and custody and the like. I don't know how the court wants to handle that with a quick turnaround. What I don't want to do is do anything today that imposes on both parties' ability to negotiate in good faith as early as next month. That is a quick turnaround. Counsel and I have discussed that. I've discussed that at length with my client. I think everybody's in agreement with that. But we do need some information on the Bahamas, do need some information and some guidance on the schedule moving forward between now and then in hopes that we can be successful. But cases you think never in a million years would resolve do, cases you think are on the verge of resolving don't. So that's kind of the issue with mediation. I'll leave that up to the court's discretion to give us how much you want to go forward today and in what capacity. I'm prepared to present my client's case. I know Ms. Pinkerton is prepared to do the same. It's up to your honor to give us direction.
Okay, well, this, I believe, was originally a motion that was filed by Ms. Bennett pro se, then it was an amended. I'm not sure if there's another motion, frankly. So the motion I have is the one she filed pro se back in the 5th of February.
Yes, motion for temporary orders, and I believe
Right.
she's seeking a parenting plan, correct? So as far as the motion compared to the petition, the main change in the petition is at the time we were under the impression that the state would have an interest, and we wanted to make sure that the petition was reflecting on the fact that there might be some child support issues at play. However, her motion for the parenting plan is basically the foremost issue at this point in time. We did since learn that the state does not indeed have an interest in this case. So as far as child support is concerned, that's going to be an issue, but it's really not top priority, and hopefully we can deal with it at mediation.
Okay. So is there anything you want me to do today?
We would like a ruling as far as the Bahamas trip. From what I understand, if my client has been in contact with the airlines have indicated to her that they need either some sort of written letter from the father indicating that she has permission to take the child with her to the Bahamas, and or basically a court order saying she has permission to take the child to Bahamas. If he doesn't go, of course. Quite frankly, there is a plane ticket. There's it's still in place for respondent. However, and my client has been very open. She's saying if he wants to still go, he's allowed to still go. We won't make that decision for him. If he wants to go, he's more than welcome to come. But as far as making sure all of our bases are covered and making sure everything's above board, we do want to make sure the child is allowed to go with Ms. Bennett to this pre-planned Bahamas trip. It's been on the books since November, long before the breakup, long before the petition. And I'm looking at the itinerary right now. It looks like the flights are leaving Portland to Miami to Freeport at night. So the child will be asleep the whole entire time. It's not one of those situations where they're hopping to and from airports every 2 hours. The child should be pretty darn comfortable if he is able to stick to his sleep schedule. So as far as concerns about going from airport to airport, it's really not the case. Again, this has been planned for quite some time before this court case even came into existence. So she would like to make sure she's able to take her and her child to the Bahamas with the rest of her family.
And to answer your question.
And that's the only issue you want dealt with today?
Well, I don't think so. I think we need to address, my client's primary concern is the Bahamas. Is probably 1B to the parenting plan and schedule moving forward, which is 1A. That's what we're prepared to address today. I can certainly give you my comments to that Bahamas trip. I, for the life of me, can't imagine being on a plane at 45 years old, let alone a 10-month-old who's traveling across the country at night to Florida, then to the Bahamas, then doing the same trip back a week later. I'm not sure what a 10-month-old gets out of a trip to the Bahamas, first and foremost. My client, again, has significant concern about the impact and the toll and the benefit, whatever that is, again, of a 10-month-old doing that kind of transportation, especially when barely a month ago, this child was staying in my client's exclusive control for upwards of 11 days while mom, who apparently loves to travel, went on a cruise to Florida and then down to the Caribbean, is my understanding, or somewhere along that path, and came back. So as far as that goes, my client is not eager to go on the trip himself, given the circumstances. That was never his intent. And number two, is certainly not keen to the idea of this young child traveling back and forth between Florida, the Bahamas, back to Florida, back to the local area in a week's time. Would also suggest, and again, this gets to somewhat of the crux of my argument related to this parenting plan, is some of these ideas and these notions of mom who says, well, I had a great time in Florida. I think I want to move there. And oh, by the way, I'm going to take the child. So my understanding is the Bahamas is not subject to the Hague Convention either. So given some of mom's, knowing that my client has no interest in going, part of my concern from a legal perspective is, great, we get the child down to the Bahamas at 10 months old who's really can't engage in anything fun like the traditional sense of an adult that would want to pursue in the Bahamas, then is potentially not able to come back because of we're not connected in the Hague Convention. So that, I think, is a legal concern. My client voices for you his practical concern, which is, again, what's the benefit of this 10-month-old child moving back and forth? I think that's number one. I think that's rather common. Number two is the parenting plan, the visitation, the custody. Now, my client went to great detail to give you his concerns about that, what our proposal is. Nobody is trying to shut out the other parent. I think that's reflected in my client's declaration of responsive pleadings. What we would like to see is basically maintain the status quo. My client tells you that he's had largely primary custody of this child. Considering January when mom went on that on that vacation, again, down to the same area, was gone for 11 days. My client cared for the child. My client tells you, not only in his declaration, but the lay witness declarations that we've given you as well from various individuals, that he's well attached to the child. The child is beyond comfortable in his custody. And he does we would suggest, and I know this is where the swearing match comes into contest, majority of the primary caretaking functions that we traditionally see. We've got two parents who are capable of doing that. We've got one who goes to work and then comes home and cares for the child. That is literally his life. He works that Tuesday through Saturday, early mornings. He leaves at about 4:30. He gets back at about 12:30 in the afternoon, cares for the child while the child is awake. Mom works something vastly different. Mom works nights, Friday through Monday evenings. She doesn't usually get back until at least 10 o'clock, sometimes 11 o'clock at night. And the suggestion is for her, okay, well, wake the child up, let's start again. We don't think that's appropriate. Parties currently own a home together. They're living in Woodland. My client tells you that the schedules are directly contrary to each other. What he's proposing for a parenting plan, pending mediation that council speaks of, again, I think is what the status quo has largely been, which is when he's around, he has the child. When she's gone at work, he has the baby, and vice versa. So you get about a 4-3 schedule, and that's what we've proposed. He has the child, and again, I don't want to misspeak what we have, but my client essentially has that child Friday through Tuesday, and that would be the exchange. So again, the 4 overnights compared to her 3, that's what this baby is used to. It eliminates a lot of transitions. That house, again, not subject to the parenting plan action before you today, is going to be sold. It has to be sold. Nobody can afford it. So basically what we're talking about right now is, with both parties living in the primary home, there doesn't need to be support. The parenting plan, they're making it work. But we're asking just the parenting arrangement be recognized for what it is, and that's largely what my client has recommended. So it gets a little bit cumbersome when we come down to that issue, but we absolutely don't think it's a good idea for my client to go to the Bahamas. We really don't think it's a good idea for this baby to go to the Bahamas. And pending that house being sold, we think that the parenting plan that we have set forward is the one that's in the best interest of, again, this very young man. So that's where we're at. I can get into further detail. We've got these issues with what seems to be, to me, mom teetering back and forth between wanting to move to Florida and maintaining now through this action. No, I really want to stay in Washington. That's kind of been an issue from the onset. We also have these issues of mom who uses the 911 dispatch as though it's some kind of personal legal reference for her. And again, it's not. We've given you information not only from my client about recent incident back in, I believe it was January or February, but my client's stepfather, who, what does Scott McDowell say? He says, I want to stay out of this until we start seeing it, in directly where police are showing up doing welfare checks, just simply because my client didn't answer a text or she didn't like his response when she asked him for help. So again, we have that. We have this Tillamook trip where my client, everybody knows, is going to take the child to Tillamook again for an extended stay. He does that. The child is fine. The child is well taken care of. My client, who's trying to enjoy time with extended family, doesn't respond to a text message or a phone call the way that she wants to. So what does she do? Threatens 911 interaction because she wants to basically dictate what he does. You throw all this together. Now you throw some of these concepts of her saying, well, I do want to move to Florida, going so far as to say, well, it would be fine if I did that. The court's going to do what I want because I'm the female and I'm the mom, and that's just the way it works. We have repeated accounts of that. To then go so far as to say, well, we could go 3 months on, 3 months off for this child until he starts school, and then we'll just have to figure it out. Shows more than just a notion or misunderstanding from my client related to this Florida issue. We have questions, we have concerns. I think that's founded largely in what her comments are. We have information from third parties, which largely validates that. We have information from third parties, which states that my client is not only a capable father, but a very good father, who his working life is his working life with Pepsi. His home life is his home life with the child. And again, that's a good thing. That's a good problem to have. But what is not a good problem to have is a lot of this back and forth of, and it's interesting to read her declaration. She says, I have no immediate desire to return to Florida. Okay. I have no imminent desire to go back to Florida. I've made no plans specifically to go back to Florida anytime soon. That's a concern. If she were to get primary custody again, and it's not workable what they've suggested in her proposed parenting plan. If she were to get primary custody of this child, what does that do for that relocation and that move? That puts her in the driver's seat when it comes to the presumption under the statute of the Relocation Act. And again, that's what we need to be cognizant of. That is my client's concern. Frankly, as a practitioner, I've seen all too many of these cases where they say, well, I'm not going to move anytime soon. And then as soon as the ink is dry on the parenting plan, sometimes before, what do? We get hit with the relocation notice. This seems to go in that direction. And that certainly seems to be one of the concerns we have. And she doesn't tell you I have no desire to ever go back to Florida. She says I have no immediate desire to ever go back to Florida on an urgent basis. That's a concern. So what we would like to see, and again, I agree with counsel. I think mediation would be fantastic for these parties. But in the meantime, we got to have some assurance that this child is taken care of and we're not going to be hit with some kind of, I'm going to move to Florida. Therefore, I want primary custody type of a situation where she gains that advantage under the statute. We are asking you to adopt my client's proposal. I think it makes sense for a variety of reasons on an interim basis until we can springboard into mediation. I would agree with counsel and concur that we need some kind of direction on this Bahamas trip. Again, I have no idea how we can suggest, well, the child will be asleep because the plane ride is in the middle of the night. Again, I don't think that's borne out by anybody who's flown can comfortably sleep. That's offset by the benefit of all of us wanting to see a new area and have a vacation. I don't think we can make that pitch and spend that so far as to assume a 10-month-old child is going to get that same benefit and be able to recover like an adult. And again, as a practical concern from a legal perspective, not having the Hague Convention apply to the Bahamas, having mom who says, well, yeah, I had a great time in Florida. I didn't really want to come back. That's of concern and of note. And that Hague Convention becomes paramount under that analysis. That's where we are. As far as child support, I would agree with counsel. I don't think it really applies. These parties are living under the same roof right now, kind of coming and going according to their work schedules. My client details for you, he has plans to move in with his folks who live in Battleground. I think that's great. They are good people. One is a retired Multnomah County Sheriff, and that is Mr. McDowell, who made the declaration. The other is his mother, who has flexible schedule because she owns her own business in Battleground. There's a lot of positive things we have that we can springboard into. But right now, we got to figure out the Bahamas. We got to figure out a schedule for when the house sells and what the parenting plan is going to be. And I think ours makes the most amount of sense. So we're not waking this poor child up at 10 o'clock at night, 11 o'clock at night to go back to mom's just so she can say, well, I want to have primary custody. It's an imperfect result for an imperfect situation, but that's what makes the most amount of sense. That is in this child's best interest. And that's why we're asking you to adopt our parenting plan.
And Your Honor, since we started with the Bahamas trip, and then Mr. Sandy took the Bahamas trip and went into the parenting plan issue. We would like to have an opportunity to pitch our parenting plan, which has been the parenting plan that this child has been practicing and is used to.
Sure. I mean, just go ahead.
Absolutely. So first of all, the parenting plan that my client has proposed is indeed the parenting plan that they have in place. It's not a situation in which they're driving the child back and forth. She very clearly details in her reply declaration, the child is brought to the house earlier in the day by father. When mom comes home from work, father leaves. The child has a sleep schedule that is built around this schedule. And we are asking to implement it. That is literally why we filed this motion, because we need to solidify the plan that has been in place, that they have been practicing. Again, this should be going to mediation, but we need to submit the plan that has been practicing for the sake of the child. Additionally, we are asking that provisions be in place because, as respondent admits in his declaration, he shuts off his phone when he has the child. He took the child to Tillamook. He shut off his phone. He takes the child from his mother and shuts off his phone because he doesn't want to deal with her. He wants to do the silent treatment. He's brokenhearted about this.
To anything that's not
That is-
in the pleading, we certainly didn't admit that we shut off our phones.
He states point blank in his declaration, I do not have my phone on when I am, because I don't want to be with her.
I'll allow some latitude. Go ahead.
So he is giving her the silent treatment, and that is irresponsible when we have an infant in play with no rules at play. If it's controlling to want to say, hey, has the baby been eating? Hey, has the baby had a nap? Do you have enough diapers? Do I need to come and help? That's not controlling. That's good parenting for a child. What's bad parenting is ignoring those assistance requests just because you are too heartbroken to respond. That is not going to be a good co-parenting mechanism unless there is a parenting plan in place. There has to be some rules in place because the silent treatment, the shutting off the phone while having an infant, a 10-month-old baby away from his mother, that is not going to be okay. There has to be some rules in place. If he had been able to communicate effectively, my client would not have had to do a welfare check to make sure her baby was coming home. This wasn't a 911 call. This wasn't I'm going to call the cops because you're not giving me the response I want. This was, I don't know if my baby is going to be brought home. I'm not getting answers from anyone. I've been told not to contact parents or grandparents or anything of that nature. So what am I to do if I don't know what's going on with my child? There's no parenting plan in place. There's literally nothing from preventing him from just taking the child, going beyond Tillamook somewhere else. It is interesting because they keep harping on this. Oh, she's going to move to Florida. Oh, she's going to move to Florida. Why would she file a petition here in Cowlitz County if she was going to move to Florida? If she wasn't planning on staying, she just created a whole big hurdle for herself by filing this case here in Cowlitz County. Her father lives down the street from her. She has a job. She has friends. She has a support system. She's been very clear from the onstart that she's not moving to Florida. She's been here for 2 years now. She's not going to Florida anytime soon. They keep saying, oh, she loves to travel. She keeps leaving. They cite 2 events in their pleadings. One in November of 2022 when she was pregnant and went to her family, in which you can see the text messages that we submitted as exhibits. They threw her a baby shower. How amazing is that? They got to participate in this family tradition of having a baby shower to celebrate this baby. And then over a year later, she goes with her family and her sisters to Florida and a cruise with the permission and the guidance of respondent and his family, which is interesting because respondent up and takes this baby from his house and moves in for the entire week with his parents' house. If you look at the text messages, oh yeah, I'm going to go back to our house and check on it tonight, because they've been sleeping the whole entire time with grandma and grandpa is taking care of the baby. There's literally a text message in which grandma is the one giving the child a bath and communicating directly with my client. This individual, instead of being primary parent for 1 week, uprooted this infant completely disrupted his schedule to take him to somebody else to have somebody else take care of the child. That shows that he is not willing and able to be this primary parent. Additionally, there's text messages from that point in time in which he is deferring to my client who is in Florida for guidance on how to take care of the baby. Oh, we're down to these packs of breast milk. What do we do? Oh, you will need to supplement with formula. Please supplement with formula. She is the one guiding him on how to take care of the baby while she is with her family. She was with the child's whole entire life, and now she's getting flack because she went and visited her family for 1 week. The whole entire time, she was still directing parenting to respondent. Respondent then goes and takes the child to his parents' house and has mom doing bath time and taking care of the baby and feeding the baby. It's showing that he doesn't know how to take care of this child. It's showing that he is relying on others to take care of this child. Now, again, the current parenting plan that they have in place has the child with my client all hours of the day other than when she is at work. When the child is with father is when my client is at work. The father brings the child to the home and waits for mom to come home from work. There's no waking the baby up in the middle of the night. There's no waking the baby up at 4:30 in the morning. It's literally the baby is at home. Mom comes home and takes care of the baby. Dad leaves and goes back to grandma and grandpa's house. He might say he hasn't moved out, but he hasn't been sleeping there more than 1 or 2 nights a week ever since these individuals broke up. He says he has all this proof that he still lives there, but yet the only thing he did submit was his pay stubs that have a completely different address on them from when they even moved into the house. So quite frankly, he makes all these allegations about my client saying she, is doing all these, bad behaviors and all that. There's absolutely no proof of any of that. There's no messages. Oh, I'm moving to Florida. Oh, I'm wanting to rekindle a romance with my ex-boyfriend. On the contrary, we submitted those text messages clarifying that she was in a situation where when she was in Florida in January, she ran into her ex-boyfriend and it was a really traumatic experience for her. Respondent, oh, I'm so sorry that happened to you. That's awful that happened to you. But yet now he's turning it around and saying that was all her fault and that she was trying to get it back together with this ex. It's completely incorrect assertion of the actual facts regarding these two individuals. We provided proof showing that these allegations that he's made regarding her character are completely false. What we have here is we have an excellent mother who spends every waking minute that she's not at work taking care of this 10-month-old baby, breastfeeding this 10-month-old baby, making sure that this baby has diapers when he goes and visits dad. Whereas we have dad who does work. He's been working and he's been making this schedule that my client has outlined in her parenting plan work. They've been doing it. Now, it's been difficult because of this silent treatment aspect. It's been difficult because when she wants to make sure the baby is being cared for, she's getting walls, nothing but walls. We can't have walls and silent treatment when there's an infant with a significant amount of needs. All infants have a significant amount of needs. That's just the very nature of taking care of a baby. She is doing her best to try and be a parent through this situation. She's doing her best to be level-headed. Opposing party literally just tries to throw darts and darts and darts at my client's character. All the while, all she's doing is trying to cement the routine that Eben has in place. That's all she's trying to do. She's trying to make it show she doesn't have to call and text in order to make sure her baby's being taken care of. She additionally would note there was absolutely no issues on respondent's end when this Bahamas trip was booked in November. He literally changed his mind as soon as she filed this petition. That's where he's coming up with this whole, oh, I'm afraid of traveling and all of this. First of all, we're not here to judge what other parents are doing as far as enriching their children's lives. There are many, many articles. I literally just read one in NPR last month about the joys of traveling with infants and exposing the world. I'm just saying.
Counsel,
far beyond the.
Just if you can stick with the declarations out in front of me.
I'm saying there has been no objection to the trip to the Bahamas when it was planned and booked last fall. Now that they are broken up, he has all these judgments. Why would you want to take a 10-month-old to the Bahamas? Why wouldn't you? There's a whole big world out there. Why not try to enrich this child as best we can early on? She's not going to abscond to the Bahamas. My goodness, that is going beyond even what's in the pleadings and declarations. That is going just to significant levels of pure imagination, quite frankly. She's not going to take this child away from her house. The child is in the safety of her mother, the child's grandmother, and all of her mother's family. They're not just going to uproot their lives and barricade themselves in the Bahamas for this. She has shown in her pleadings, she has been more than willing to work with respondent. However, it's difficult to work with somebody that shuts off the phone when you try to help and call and try and check in on their infant. There's literally no fear of her absconding to the Bahamas. There's no fear of her moving to Florida. It's not going to happen. We cannot make it any more clear. It's not going to happen. The fact that they keep harping on it shows that they're not willing to listen. All they want to do is just paint mom in a bad light, throw darts at her. She didn't do that to opposing party. She said, he's a good dad, but he doesn't answer the phone. He's a good dad, but he lets grandma take care of everything instead of him. This is the situation. These folks should be able to go to mediation. These folks should be able to come up with a plan, but there has to be some leeway. There has to be some communication. There has to be some understanding. We are asking you to allow my client to move forward with the Bahamas trip, something that's been planned since last fall, bought and paid for in November, long before this situation ever arose. We are asking you to grant our parenting plan because that is what Eben is used to. That is what this 10-month-old is used to. And that is what they have been practicing. Mom has been the one taking care of Eben. She's taking care of him right now. She's on Zoom right now with the child. We are asking you to
Hold on one second. I'm getting some feedback from somebody here. Just a minute. I'm going to mute. Go ahead.
Thank you, Your Honor. We are just asking you to submit the plan that they have in place. It's detailed significantly in our reply declaration. It's what they've been doing. And she again explains how they've been doing it as opposed to, dropping the kid back and forth. That's not what's been happening. As such, we just need to keep some rules in place so that there's no confusion, no need to call, text, and that we can move forward with this Bahama trip.
Your response?
Yeah, just very briefly. And again, confusion is in place because these parties still live under the same roof together. So how we can have a parenting plan in which both parties are still living in the same home is the basis of the confusion. That would make, just again, if you're willing to consider what's well outside the scope of the declarations, and that was a lot of the argument I heard from counsel, that would state for you that the copies of what we got in the exhibits, as far as the text messages that are being cited, as far as the calendars, I can't make heads or tails of any of these communications or what's on the calendars. Basically, the only thing I can see is the January 2024, December 2023, as far as what's contained therein. I can't decipher what any of that is. As far as what's contained in the text messages, again, I run into the exact same problem. So that is somewhat concerning, and I don't know what the text messages are. The copies I got are extremely blurry to the point of being unrecognizable, many of them. We look at the best interest of this child. Again, that's the standard. If we look at the initial pleadings filed and submitted by Ms. Bennett, again, there is misnomers in there where she claims the fact that this is what we've traditionally been doing. Well, nothing's been traditionally done because these parties are still living under the same roof, which is why we get very vague information from what was filed and submitted on Ms. Bennett's behalf. You can't really do that. The Bahamas trip, again, I'll rest on my statements from prior because nothing that was contained in counsel's response really gives me any indication that that's really in the best interest of the kid, because it's not. And as far as this parenting plan, again, this is all prospective because, again, we still live in the same home. What he decides to do with the child over his time and what he decides that she decides to do with her over her time is her time. That's her choice. But we can't assume and we can't state, well, this is traditionally what's happened. When these parties have lived under the same roof since September, which is when they bought the house in Woodland, they both own the house together. They both come and go from the house together. Moving forward, I don't know what's going to happen to this. What's going to happen at mediation? I don't know. But to make arguments and make assumptions about, first of all, what's contained outside the scope of the pleadings is in there. And second of all, what happened since these parties have been separated? Well, they're not physically separated. They're emotionally separated. So you can make that pitch both ways, and that continues to be the issue. That's where we're at. I would sustain my objection, or excuse me, continue my objection as to court considering anything that's outside the scope of the pleadings, or considering historical elements of what these parties have done when they lived together. Again, I think would be in there. That's where we're at. We've got a dad who's been highly involved, who wants and will continue to be highly involved. We've got a mother who, again, counsel statements, doesn't have any immediate plans to move to Florida anytime soon. Again, and that's directly out of Ms. Pinkerton's argument that she just gave. We have the luxury of having not only a well-informed, a well-prepared, a excellent dad, but we do have the joy of having, again, the benefit of having an extended family who is there and readily able to help with a young child who the child is bonded to. That's where it's at. That's where we are, and that's what we're asking the court to adopt moving forward, if you're inclined to do anything with that parenting plan, given the somewhat unique circumstances.
And just one last response, since we were the moving party, it's clear when he has a child, he is not in the house. He takes the child to his parents' house, he takes the child to Potomac, and then shortly before mom gets off work, he brings the child back to the home where they do the exchange. He's not sleeping there more than 1 or 2 nights a week. So to say that they haven't separated,
Object to anything outside the scope of the declarations.
that is literally in the declarations. So as far as that's concerned, we would note that's in the record, that's in the pleading. Additionally, these arguments that why would anyone want to take a child to the Bahamas, that is not in the pleadings, and we'd ask that be stricken.
Hang on. Same objection. Anything outside the scope of the initial declaration.
All right. I reviewed all the declarations. That's the only thing I'm considering. So.
Thank you.
Okay. So this is an interesting case. What am I inclined to do? I'm not going to adopt either of these parenting plans at this point. First up, I can't completely make heads or tails of the details on what the schedule looks like when I read through them. But what I'm going to do, I'm going to order a joint parenting plan, so joint custody at this time, both parties listed as primary. And essentially a 50-50 plan based on the time they have available from work. As far as the Bahamas trip, I mean, having traveled with a 2-week-old to a much older child, it's a long flight to southern Florida, and it's a longer flight to the Bahamas with a child on your lap or however you do that. But that being said, and I can tell you my own son, he's been places when he was 3 and 4 years old and doesn't remember those places. So I guess my feeling on it is that I mean, both parties have tickets to go. There's no reason they both can't go. So what I think I'll do at this juncture, I'll authorize the trip so long as both parties are able to go. It sounds like the tickets are available. And while they're there, they have 50-50 time with the child. So they don't have to spend it together, but the child is 50-50. If you want, I think it's probably as far as I'm going to go. If you want, I could either appoint a court investigator to look into this a little bit more, or do you want to go to mediation first?
I think we go to mediation before we appoint a guardian ad litem. I think that makes sense. If we provided we can get in there anytime soon. If we can't get it done at mediation, then I think automatically we send it to a GAO. I think that should be reflected in the order.
Counsel?
The only thing I would ask, we have no issues with that. As far as the GAL is concerned, costs associated to it, I do believe that respondent did make a request for that. He does, at least based off his own pleadings, and make more money than my client. So we'd ask that he be the one that be in charge of those fees.
Based on our pleadings, see, they don't make more money. They just applied for that loan that said they both made equal amounts. Based on her pleadings, it shows $30,000 in reported income, which doesn't give anything to the tips that she makes. So
here's what I'm going to do. I'm not going to appoint a guardian today. I'm not going to authorize a guardian today. Let's go through mediation, see how that goes, see if there's a need for that. This is probably a case that I'm not sure. I mean, we don't have horrible allegations going either direction. Again, that may be something that a court investigator could handle just as easily with less expense to the parties. But so when do you want a presentation on this?
2 weeks would work for me if that works with Ms. Pinkerton's schedule.
I believe that would work for me as well. So the 26th.
26th at 1 o'clock.
Perfect.
So if I'm understanding, the trip to Bahamas can happen for the child, provided both parties can make that work and both parties go. If both parties do not go for whatever reason, then the child stays here.
No, the child goes on a trip. He can go along and he has half the time of the trip with the child.
Okay.
So, I mean, you're both going to want half the time with the child because otherwise you're not going to have much of a vacation in Bahamas.
And if we wanted to come up to with an agreement, you know, if
you guys can do whatever, you can agree to anything you want to. I don't have a problem.
Right.
That's what I'm going to do.
that might be a discussion for Mr. Zandy and myself, but yes, thank you.
And I'm not going to get in the way of that.
Right.
Okay.
All right.
Fair enough. Thank you, Your Honor.
See you in 2 weeks.
Thank you.
There you go. All right, go ahead.
Thank you, Your Honor. Your Honor, just to kind of catch you up from where we were last week, we have struck our request for a GAL and the motion for GAL, primarily because of the age of the child. The parties have agreed to communicate through our family wizard, and we've agreed, at least as to today's motion and the restraining order, we agreed that each party is going to pay their attorney's fees. I think we have an agreed list for items. We do not have a date for my client to pick up his personal property. And so the primary issues for you, Your Honor, is to set child support incomes. We have to deal with my client's request for the Honda passport and set a date for the personal property to be retrieved by my client. Whenever, okay.
Are those the only issues, are really the support, passport, and the exchange date?
I think we
Yes,
still have to address the parenting plan as well.
Yeah, there's some parenting plan issues. Yes, you're right. She's right.
Okay, got it.
So on the financial, first off, petitioner claims financial abuse and states that her income is a set amount. And yet I find this very disingenuous. She owns her own business and she can set her draw at whatever she wants, whatever the business will allow. It's at her discretion. I looked at the bank statements and her deposits really are not consistent. There are large ones, small ones. They fluctuate all the time. The child is 17 years old. She's going to be 18 in November, but is a junior year in high school. She wants to live with my client and does not wish to be restricted by a set schedule that could subject my client to contempt should the child choose not to visit. Mother seems to want to force this issue and require a set schedule of 50-50 timeshare, which she may not realize will only push the child further away. Back to the issue on financial abuse, wife's own text messages show that every time she was locked out of that QuickBooks account, my client was right on it, allowing her access. And he addressed this in his reply declaration. He unlocked it constantly without a fuss. He never questioned her motivation, never challenged her, always was on it immediately and got it cleared up. And after another month or so, the whole issue was resolved. So her point is moot anyway. The bottom line is, Your Honor, that is not coercive control or financial abuse. It is coping with a problem pending resolution. With regard to the Honda passport, all of the vehicles are owned by the business. So they're all in her name and the name of the business. She has multiple other vehicles at her disposal. The passport was purchased with the intent that it would be my client's car to drive, primarily. And she has now reneged on that agreement, leaving my client with a very impractical vehicle, a Nissan 350Z. It's very small. It's not conducive for a dog and a child. He requests use of the passport. She does have other vehicles at her disposal that are in perfect working condition. My client says that she's just doing this to be spiteful. She's just withholding it. The tax debt. My client acknowledges that the tax debt is a community debt and will be resolved in the final orders, where she will obviously receive a credit for the payments made against her share. That does not dismiss her of the obligation to support this child. I also want to note for the court, those third-party declarations that support mom, those are people who work for her and have known her less than a year. So those are her employees attesting to all this stuff. I find that rather disingenuous and suspect. I do believe we are going to be having a CR2A agreement on a number of these issues, but with specifically regarding the custody and residential schedule, my client is requesting that it be left to the discretion of the child. The child and mom can work out their own visitation and their own plans. My client does not wish to have it be a set schedule, and neither does the child. The child has her life too. And she's just going to be more and more independent as time goes on. So there's really no point in tying her into a 50-50 schedule. I also think that that's motivation by mom to try to avoid paying full child support to my client. So that being said, Your Honor, we are requesting that mom hand over the passport to my client, so that he can have that more practical vehicle to drive. That child support be set based on, well, it's hard to say what her actual earnings are, but it's important to note that she can be flexible, and a lot of these expenses that she's claiming are tax deductible. That money gets offset. You know, not all these expenses are allowed under by the family court to be included. So I do have some issues with that, and I asked the court to take a very close look at that in setting her income. Again, where child support's not going to be for more than a little over a year. And the child does want to live primarily with my client and not be tied to a schedule. So we are asking that you adopt our proposed parenting plan, allow my client to use the Honda, and we need a date certain by which my client can pick up his personal property, and I would prefer that to be this weekend.
All right, thank you. Ms. Baldwin?
Thank you, Your Honor. In this matter, first I'm going to address the parenting plan. We do have a 17-year-old. She turns 18 in November. This is her junior year. She'll enter her senior year this upcoming year. There's some practical realities of dealing with a child that is approaching the age of majority. And I think that that's sort of conceded by the fact that they've agreed that a guardian ad litem is not appropriate. That being said, you clearly see that we have a young person that is sort of pulled between two parents. A young person who is pulled between a parent who says, you used some drugs, you drank and got an MIP, hey, kiddo, no big deal. And another parent says, hey, that is a big deal, and I'm going to talk to the school resource officer, I'm going to talk to the counselor, and hey, maybe you should get some substance use and abuse counseling, and hey, maybe we should get some other services on board to make sure things are okay. And so we have one parent that sort of is trying to backstop this child and make sure that sort of safety is in place, and another parent who kind of just takes the laissez-faire approach. And not too unsurprisingly, the 17-year-old says, hey, one parent's a lot easier. And that doesn't come as a big surprise or shock to anyone here. My client is very realistic. Her parenting plan it's a 50-50 parenting plan, but it's one that's largely built around the idea that there's some set times and a lot of flexibility. The set times are essentially the weekends, that we would set in the weekends and say, this is dad's weekend, this is mom's weekend, this is dad's weekend, to make sure each parent has dedicated time. But it would give flexibility to the child and to the parents that during the week, the child could have flexibility to say, hey, I just blew up at dad's house, I'm going to go be at mom's this week. And now I'm mad at mom and I'm going to blow out and I'm going to be at dad's this week. And that makes a lot of sense when you're dealing with a 17-year-old to have some flexibility for a child this age, and a child who potentially is at one house. And then you have a parent says, hey, no, like we need to sit down and buckle down because you're currently failing all your classes, and maybe get some stuff done. And then we're in another household, maybe the other parent, maybe you have a child who realizes, oh, I'm failing, I might need to go to the other house and get some support that isn't available to me at one house or another. So that allows flexibility. It also, though, ensures that the child sees each parent and neither parent gets completely ostracized during this process. Leaving it completely loosey-goosey means either mom or dad can have a situation where they don't see the child at all. I think that actually is very inappropriate to create for this child and will put the child in a very poor position. Although we did propose 191 factors, I think there's plenty of support for them. Again, my client's realistic. There's not a lot the court can do in essentially, what are we at, 8 months to cure any of those factors. We're not necessarily asking the court to find any of the 191 factors. I think there is evidence that would support them. Nonetheless, there's just insufficient time to cure any of them or to do anything about them in this case. Mr.'s claims that he makes are wholly unsupported. He says that the best that he can come up with and drum up with is mom made personal attacks. Essentially, I don't like what she said about me. He gives no examples, no dates, no times, no what was said. So again, there's no support whatsoever. It's just essentially my feelings got hurt at some point in time, and I can't even tell you what happened. Mom, on the other hand, gives specific times, dates, examples, and photos of what happened. So very different recitations. Concerns here regarding the driver's license of the child. My client essentially concedes that Mr.'s going to have that happen. My client says my client would not let the child get the driver's license because she hadn't completed driver's education and hadn't done the requisite amount of essentially supervised driving. In order to get that license, Mr. said, hey, I'll just sign off. You can go get your driver's license whenever. My client obviously concerned about that. Mr.'s going to sign off. Again, practical realities here. So my client recognizes that. Admit that that's going to happen. She just says if that happens, Mr. should be responsible for the vehicle insurance because he's essentially making that choice. He's the one that's signing off that the supervised driving happened. He should be obligated then for the insurance associated. Both parents should continue to have access to the child's grades and attendance until she turns 18. The parenting plan should have very strong prohibitions against the child using any kind of drugs or alcohol. Obviously, those are not appropriate. And then should also include very strong requirements that both parents are obligated to tell the others of any arrests, hospitalizations, or similar interventions that occur with the child. So that both parents then ideally will rally around the child in these final months before she becomes an adult. So our parenting plan is practical, it's realistic. But it's also built around a child who frankly is going to make a lot of her own decisions. We just want to maintain good relationships with both parents and not sort of put the child completely in the middle. And their parenting plan is essentially telling the child to choose the entire time. We're blocking in weekends for the child and then allowing the rest of the time for the child to make some decisions. As to incomes, my client works at and also is the owner of a business. Is essentially a social services business. It takes in contracts from the state and other groups, works with homeless populations and other vulnerable populations. The child additionally periodically works for my client at that business. The idea that like many business owners, her income is not necessarily month over month exactly the same. For the purposes of a child support worksheet, we have to choose an income. And so my client says this is the income, that $7,500 is the income if you were to average it out as the monthly gross income that she would have as essentially gross take-home income. But her income is not wildly flexible. Sort of the claim that she can sort of liquidate whatever money she wants at any time obviously is not true. Of note, these folks have a massive IRS debt of almost $200,000. That does not include what they owe for 2023. And it's my understanding these folks didn't pay their taxes in 2023. So there's also to be added to that dollar figure, everything from 2023. The IRS will get theirs. So the idea that my client can just choose not to pay that is inaccurate. The IRS will get their money from my client one way or another. It's clear that Mr. is not going to pay it. They understand my client is frankly the only one that's going to be responsible for this. So that needs to be calculated when we're looking at my client's income, and that's what we've done, is put her at the $7,500, applied normal taxes, but then also calculated in the IRS payment for a net income of $3,421. As far as Mr's, and we provided some documentation, I believe, as to that, and provided you a copy of one of her payments to the IRS as well, showing that there is an active payment process that's happening. Mr's income, he provided no documentation. We don't really have any documentation of his income. My client doesn't really have a good understanding of his income because it looks like it was segregated. But nonetheless, it looks like his income is, we put him at $6,222 per month gross. Correctly applying his taxes puts him at $5,057 per month net. That's only about $40, $50, $30 off of, I think, their claim. So pretty close on his income as far as for the child support worksheet. We're asking the court to adopt our child support worksheet. My client's income is accurately calculated. Their client's taxes are accurately calculated. The court should apply some credit depending on what the parenting plan Your Honor chooses. That would be appropriate. Additionally, I'll note that their parenting plan just has a random $300 thrown in there as like a cost that's completely unexplained. There's no declaration statements. There's no reasoning behind that. That's not appropriate. We did not do that in our statement as well. As to property, we are largely agreed to a personal property transfer. I'm just asking that council and I work that out within the next 2 weeks, but the transfer should happen within the next 2 weeks. My client's got it already and boxed and it's in the garage. So that my understanding is that should not be a major issue. We would ask that happen through a third party though, and that Mr. not come to my client's home. Otherwise, parties are agreed my clients to remain in the family home. It's my understanding that Mr. has found his own home and that he's rented separately. So that does not appear to be disputed at this time. Vehicles are the next major issue. They're not all titled in the business name. There is a Honda Pilot. My client would firmly dispute that there was some kind of agreement. This is the car that she personally drives. It is also titled in the business name. It is a car that is used by not only my client, but also it is used directly by her employees. They use it to transport clients, essentially homeless folks. They also use it to drive around supplies and other things that they need in order to service the clientele that they're using. It's a larger vehicle. They're picking up supplies for the homeless population that they serve. So that's necessary. It's the car she's driven for the last several years. It is titled again in the name of the business. The Nissan that Mr. is driving is titled in their names personally. It is not titled in the business name. That is the vehicle he has driven personally for several years. So again, this idea that, he's driven the Honda Pilot, even he's not claiming that. So his personal vehicle is the Nissan. He should continue to have possession of it, continue to drive that. The RAV4 is an additional vehicle. This is actually Mr.'s older vehicle. So this is the vehicle that he used to drive. My client is in agreement that this vehicle can also be provided to Mr. Although it's currently titled in the business, the plan for that vehicle was for that vehicle to become the child's vehicle. My client's in agreement to transfer the title from that into Mr.'s name personally, because I don't believe we can transfer it to the minor, to transfer that to him personally. And then he can choose to do what he wants with that. But then the RAV4 can be used to transport, either used for the child or to transport other things. But that sort of takes care of that issue. There are some other miscellaneous vehicles. They are all titled in the business name, and no one's addressed those. So I don't think those are really even in dispute here. As to debts that the parties are servicing, my client agrees that she's the only one who's paid since separation. She'll pay the IRS debt as well as the mortgage on the family home and her student loan debts. Mr. should maintain his, and we believe these are separate, but his Capital One credit card, it looks like Genus Bank, Fiber Federal debt. And again, we believe those are his separate as well as his student loans. And then both parties should be responsible for any other debts going forward in their entirety. These folks should just kind of have separate finances going forward. As parties are agreed to use Our Family Wizard for communication, each should pay their own fee associated with that. The fee is very low, but that's reasonable as a way for the parents to communicate until the child turns 18. In this case, Mr. shouldn't be accessing my client's bank accounts or accessing any of the business accounts. Similarly, he should not access any of the utility accounts or utility passcodes or accounts. My client put into her declaration kind of explaining sort of she would get access to the utilities, and then he would change how they were paid and change the passcodes and the access. So then all of a sudden, like the lights are getting shut off and she's trying to then regain access and reestablish payment. He's no longer living.
I need to object to this. This is beyond the scope of the motion, and this is not an issue. It's no longer an issue. My client hasn't even tried to do anything with the household bills. So this is a waste of time.
Part of my client's declaration, that's not a proper objection.
Oh, well, I'm addressing the support, the passport, and the parenting plan. So apparently that's all I'm just addressing.
Now we're getting into utility bills at the house, and that's not before the court today.
Well, I just want to make it clear that those are not, since my client's living at the home, that shouldn't be, she should be the only one accessing utility debts or utility accounts for the home, so that does not become any issue. Again, as to the child, if Mr. obtains a driver's license for the child, he should be obligated to pay for vehicle insurance for the child. And I think that, and then each party would be responsible for their own fees for this motion.
Okay, thank you. Any response?
Yes, Your Honor. Your Honor, most of these issues were addressed in our reply declaration, so I will rest on that. the parenting plan proposed by petitioner is not realistic. It's not reasonable. It's controlling. They accuse my client of abuse all over the initiating pleadings, but then talk about how he's lazy and lackadaisical, loosey-goosey in his parenting style. That's not consistent. Those two personality traits do not coincide. So I find those arguments to be incredibly empty and baseless. Personal property transfer. I've asked for a date certain for over 3 weeks and I've received nothing. I have no confidence in my ability to come up with a date certain with opposing counsel. Therefore, I am requesting that the date be set to occur this weekend, that my client can be allowed to retrieve whatever she's boxed up for him. She can put it in the driveway in front of the garage as long as it's not raining. And if it is, she can leave the garage door open and leave the boxes there in the opening. He's not going to go into the house, but there's also no reason. There's no restraining order in place. There's no reason for that he cannot go and be outside the home collecting his things. I don't see why he should have to enlist the services of a third party to do this when there's no domestic violence, there's no restraining order in place. I note for the court that she certainly doesn't deny that there are multiple vehicles. And in fact, she's misleading the court. The RAV4 is the vehicle that is being used to transport clients. And, you know, that's the one that's being used by the employees. She drove the Toyota sedan as her primary vehicle up until the incident leading to this action being filed. That is the truth of the matter. She took the passport or the pilot or whatever it is. She took it as a retaliation and to punish my client because it was in her name and he couldn't do anything to stop her. But up until just these recent events that took place, she was driving a Toyota sedan as her primary vehicle. So she is actually extremely misleading the court with the facts here. Your Honor, the parenting plan, the child should, as counsel says, we need to be flexible. We have a teenager here who's about to age out. Flexibility is of the utmost concern. So why do we need to have a set parenting plan? Let the child and the mother work out their time and let the child live where she primarily wants to live. There have been no actions asserted or proven by my client or by petitioners stating that either parent is engaging in alienating behavior. So I don't really understand why this would even be an issue. And as far as these little passive aggressive comments of wanting confirmation that he's not going to touch the utilities, he hasn't touched them. It's not an issue. And so to bring it up is nothing more than just an effort to mislead the court as to what they're trying to accomplish and to make my client look bad. She punished my client by taking away his vehicle because it's in her name, and she left him with the only vehicle that he would have any legal claim to. That's very strategic, and that's abusive. That's coercive control, not what counsel and what she's projecting out to be. And in fact, I believe I said it first line in our reply declaration that everything she's saying is projection and deflection. She's doing all these things that she wants to make sure he doesn't do. So I find her arguments and her position very disingenuous. I'm going to leave it to the court's discretion as to child support. But I am asking that the court allow my client to have a practical vehicle and allow my client order reasonable child support and allow my client and the child to live free of mother's control and her controlling behavior by adopting our proposed parenting plan.
I guess I would just ask Ms. Petrie to identify where she's emailed me in the last 2 weeks for a date for the exchange of property. Because she indicated that you didn't believe we could come to an agreement on the date, but I'm looking at my emails and.
Okay, that's fine. So at this juncture, again, this is a case of, all these folks appeared in front of me in a different docket, which, there was the ability the court would have had with the evidence that was presented to enter fairly significant orders that declined to do based on the likely negative impact on both of their employment in this case. But fortunately, we're past that. It was also, and this is a case where the child had filed a no contact order. And I those issues are court record, what was in those, and that's concerning. My inclination on a parenting plan at this juncture is to have a very unstructured. I think this is a case where probably I could either have a court investigator or a GAL look into anything. I'm not inclined to order the child in this case to engage without some further look into the situation, because again, this is a case where there very likely would have been no contact. So I'm gonna leave everything up to the child at this juncture. I'm gonna have her residing with the father, because that apparently is what she wants to do right now. That could change. As far as the vehicles, gonna be he said, she said, but I'm gonna leave him with the Nissan and the RAV4. She can keep the Pilot for now, based on what information I have. I'm gonna set the child support based on her worksheet, which should be $531 a month. I'm not gonna do any adjustments at this time until we see what happens on the parenting plan. If you want, I can appoint a court investigator, or I can appoint a GAL, or we can.
There's so
work
little
forward.
time.
Hmm?
There's so little time. If you push out 102 weeks to get it entered, another 120 days, we'd have a report for 2 months.
It's up to council. If you want to go down that route, I'm happy to do that. I'm just.
No, Your Honor,
going to-
we withdrew our request for a court investigator and GAL.
Okay. As part of the support, and this wasn't specifically requested, but she's indicating part of the reason for adopting the child support number is she's indicating she's paying that $2,500. So she needs to do that.
Yeah, agreed.
And keep that going. Since that's the basis for the calculation. I think as far as details in the parenting plan, I think notification of any emergent kind of things obviously is appropriate. I'm going to reserve on any 191 findings for either party. And I think that's about the extent of where I'm going to go on that today.
How did you want to do decision making, Your Honor?
Well, if it's anything major, it should be joint. Any major in the sense of like major medical, non-emergency medical.
Okay.
I usually just put at 17, I put joint plus child, because there's some things that in Washington, the child could even exclude the parents from.
Yeah, understood. If it's something the parents have to get or are able to get involved in, then it should be joint.
Okay, thank you.
And then mothers still have access to educational records and attendance records.
Yes.
Yeah, I have no objection to that.
Yeah, that should all be, they should both be able to access the Skyward if that's available for both of them.
I'll add in the Children's Bill of Rights to it. So
Yeah.
all those provisions will be in there.
Okay. Okay.
Debts as we've proposed.
Debts as proposed, I think that's appropriate, at least for now. I think that's all that was in front of me. Oh, it's a date.
Can we have this, can we get my client's personal property this weekend?
And I don't have my client here, so I would just ask that it be within the next 2 weeks. It may be this weekend. I just don't have her next to me to answer that.
Let me do this. I'm going to set it for 10 o'clock this Sunday. If that's a problem from a specific scheduling issue, then council, I can resolve that through an email.
Okay.
Thank you, Your Honor.
So, but you need to let me know that before Thursday, because I won't be here Friday.
Absolutely.
Okay.
And did you want to set entry, Your Honor?
I'm sorry.
Entry?
You want 2 weeks?
Sure,
26th at 1 o'clock.
that should work.
Obviously, agreed orders are promoted and accepted.
Thank you, Your Honor. And council, the date was March 4th. Thank you, Your Honor. Is there anything further?
March 4th.
Oh, March 4th was the date of the last correspondence I had with them.
Oh, okay. Oh, outside of my bit there.
Thank you, Your Honor. Have a good day.
All right, you as well. We are adjourned.